Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Lecture 3 of Conquer Prelims 2024. I received a feedback from a couple of students regarding the questions we have been discussing in the first two classes, and I'm told that the questions were too difficult. Now today you can heave a sigh of relief because the questions today are relatively easy, but I want all of you to do well. The very purpose of asking difficult questions is not to demotivate you or demoralize you. It is to prepare you for the upcoming real examination. And if you are already prepared for the difficult questions, you can safely assume that you will be prepared for the easier ones or relatively easier ones that may be asked in the examination. Clear? But listen to me carefully. Sometimes in the real exam, when you look at a question and you think the question is easy, this is where you start making errors. Why? Because you self-doubt that this is such an easy question, maybe I'm reading something different into it, maybe the UPSC will not ask a question like this, so you will make errors. Do not doubt yourself. If you have prepared well, if you have covered the concepts, if your basics are clear, if you have updated your current affairs, there is no reason why you can't do well in the examination, why you can't be in a position to answer all the questions, at least from Indian Polity. Clear? So let's get started and look at question number 1. But the way we encourage you, you should encourage us as well. When we look at the number of comments on our videos, that encourages me and my team to work harder to deliver the best possible content for our students. So do not forget to press the like button and subscribe to our channel if you haven't yet. And let's look at question number 1. Consider the following statements regarding the Bharatiya Nagarik Suraksha Sanhita 2023 and choose the correct option. Number 1. None of the provisions of the law apply to Nagaland and the Schedule 6 areas. The law explicitly provides for the registration of a zero FIR. The law mandates forensic investigation for offences punishable with 7 years of imprisonment or more. The law provides for ex parte verdicts in certain cases. Choose the correct option. You have 1 minute. Let me know what is the right answer. If you're confused in option 1, make a guess. Okay. The correct answer is C. 3 statements are correct. Now let's elaborate. Article 371 of the Constitution, it provides for a special status for some states. One such state is Nagaland. And Constitution explicitly states that no act of Parliament with respect to the religious or social practices of Nagas, the Naga customary law and procedure, administration of civil and criminal justice system for the Nagas, ownership and transfer of land and its resources, this law will not apply to Nagaland unless and until the Nagaland Legislative Assembly approves it. That is one special status for Nagaland. And please understand, this law is replacing CRPC, which was implemented in 1973, and this law will enter into force with effect from 1st of July. 1st of July 2024, this law will enter into force. But now listen to me carefully. Nagaland and Schedule 6 areas. In Nagaland recently we saw the practice of rat hole mining, because rat hole mining is allowed in Nagaland. In fact, some of the miners also died. Then there was a criticism as well. The government in Nagaland said, we are unable to deal with the situation because Nagaland enjoys a special status because these people, they control the land and the resources, and these Naga people are dependent upon rat hole mining. That is why we are not effectively in a position to curb this practice of rat hole mining. So rat hole mining is in the news, Article 371 is in the news, CRPC is in the news, this Sanhita is in the news. So that makes it a potential question that can be asked in the examination. Even the CRPC was not entirely applicable to Nagaland. And here, this Sanhita, none of these provisions apply to Nagaland. This is incorrect. Why? Because there are chapters of this Sanhita, chapters 9, 11 and 12. They apply to Nagaland. These chapters, you don't have to discuss too detailed into it. These chapters relate to the powers of the police to investigate the cognizable offences. So these chapters apply to Nagaland of this Sanhita. Clear? That's number one. Number two, Schedule 6 areas. Now Schedule 6 area is also in the news. Why? Because Ladakh, and there are some civil society organizations, some activists who are demanding that Ladakh be included in Schedule 6 area. Now, what is a Schedule 6 area? It provides for the administration of the scheduled areas where in states such as Assam, Meghalaya, Mizoram and Tripura. But please understand, that does not mean that the entire state of Assam or Meghalaya, Mizoram, Tripura, these are the tribal areas. There are 3 districts in Assam, 3 in Meghalaya, for example, Garo, Khasi, Jaintia, 3 in Mizoram, 1 in Tripura. These are scheduled areas and they get protection under Schedule 6 of the Constitution. And what is the protection? They get a district council, and these district councils should not have more than 30 members. 26 of these members are elected based on universal adult franchise. Not more than 4 shall be nominated by the governor. And what will happen because of that? This district is to be treated as an autonomous district. What do we mean by that? We have center, then we have states. States have their own jurisdiction. You can assume in a layman's language that within a state you have another state which is run autonomously, because this district council, they will have the power to elect their representatives, and then through these representatives they can also impose taxes, tolls. They can also regulate their criminal procedure, civil procedure. They can regulate their marriage, divorce, inheritance. That means some sort of autonomy is provided to these areas which are under 6th schedule of the Constitution. They have the control over the land, resources. That is why Ladakh wants to preserve its identity, preserve its unique culture, and they want a status under Schedule 6 of the Constitution. This Sanhita can also apply to Nagaland, provided the state government makes a notification and makes some minor modifications or major modifications to the Sanhita, and then the Sanhita will be applicable to Nagaland. But long story short, which of these statements are correct? When we say none of the provisions of this law apply to Nagaland and Schedule 6 areas, that is not true, because Chapter 9, Chapter 11, Chapter 12 of the Sanhita, they do apply to Schedule 6 areas and Nagaland. So statement 1 is incorrect. The law explicitly provides for the registration of a zero FIR. Is it correct or incorrect? This is correct. But listen to me carefully. If it would have mentioned, the law explicitly mentions zero FIR, then the statement is incorrect. But if the statement says the law provides for a zero FIR, then this statement is correct. This is where you can relate it to the kind of the question that was asked in one of the prelims examination. The Constitution provides for judicial review. Constitution never provides for judicial review. It's not mentioned in the Constitution. But we can trace the concept of judicial review by looking at Article 13 of the Constitution, by looking at Article 32 of the Constitution. And in the official answer key released by the UPSC, that was the correct statement. Clear? That was the correct explanation, because the Constitution does not explicitly provide for judicial review. And what is this zero FIR? Listen to me carefully. This is where we are discussing related concepts to this particular question. For example, a crime has been committed at this place A against a victim X, but then this victim X moves to another place B, and she would approach the police station here, please register the FIR. The police normally would not register the FIR. Why? Because this is not under the jurisdiction of this police station, because the crime was committed under the jurisdiction of another police station. When Nirbhaya gang rape happened on December 16, 2012, then in response to that, Justice Verma committee was set up. And Justice Verma committee recommended that there should be a provision for zero FIR, which means now this victim can approach a police station, any other police station, for example B, and there the police has to register what is known as zero FIR, which means the complaint will be registered, but no number will be provided to this complaint. That's why we call it zero. And then what this police station will do, it will transfer this complaint to a police station under whose jurisdiction this crime was committed. And now this police station will register the FIR, will carry on the investigation. That is what we call the provision for zero FIR. And this law, Bharatiya Sanhita, it provides for zero FIR. Although it does not explicitly mention this term zero FIR, but it says that this concept, it applies this concept that you can register FIR in any police station, even if the crime was not committed in that police station. So this statement is correct. This law also provides for forensic investigation, where the forensic team will come, will take care of the evidence, but for those offenses for which the punishment is 7 years or more. So this statement is also correct. And the law provides for ex parte verdicts in certain cases. This is also correct. Ex parte, which means without hearing the other party, in your absence. What does that mean? For example, you have committed a crime. Before this law, if, for example, you have committed a crime and then you run away from this country, we cannot prosecute you. Maximum what we can do, we can declare that you are a proclaimed offender. But we cannot, in your absence, push criminal charges against you. But now this Bharatiya Sanhita, what does it talk about? It says that if there is this individual who has committed a crime and now he has run away from this country, we cannot bring him back to the country. In his absence, ex parte, we can also prosecute and convict this individual. That's what we call ex parte verdict in certain cases. The remaining three statements are correct. First is incorrect. C is the right answer. Clear? Another important concept called preliminary inquiry. What is this preliminary inquiry? If, for example, you have committed an offense for which the punishment is 3 years, above 3 years, but below 7 years. If you have committed an offense under this law, which is replacing CRPC, for which the punishment is 3 years or above, but less than 7 years, for that preliminary inquiry is a must before proceeding further. And this preliminary inquiry will be conducted by the Deputy Superintendent of Police, and the inquiry must be completed within 14 days. So preliminary inquiry, this statement can be asked in your examination, is mandatorily to be conducted for those offences for which the punishment is above 3 years or under 7 years. Clear? Another concept. EFIR, electronic FIR. What does that mean? Normally, what is this FIR? It's basically information. What I will do, a cognizable offence has been committed. A cognizable offence is an offence where the police can carry forward with the investigation without the warrant issued by the magistrate. Clear? What I will do, I saw this cognizable offence happening. I approached the police, either verbally or in a written format. I will give this information to the police. If I'm verbally giving this information, the police officer will write it down, then show it to me, then I have to sign. This is what we call FIR. So FIR has been registered. But can you submit this information electronically? Yes. But then, another important statement. Within 3 days, I have to go and give my signature. For example, I registered an electronic FIR, but I need my signature there as well because law mandates it. I have to visit that police station, sign that document, and then the FIR would be complete. There is a provision for electronic FIR, but then I have to visit and sign this document within 3 days of that FIR. So these are important details that you need to know regarding the Sanhita, which will enter into force from 1st of July 2024. Clear? Great. Let's look at question number 2. If a legislator is convicted under Section 8, Clause 1 of the Representation of the People Act 1951, but only a fine is imposed, then the legislator is not disqualified. If a legislator is convicted under Section 8, Clause 2 of the Representation of the People Act 1951, is disqualified only if he is sentenced to imprisonment for 2 years or more. A government employee who has been dismissed from service because of corruption is disqualified from contesting elections for 6 years from the order of dismissal. Which of these statements is or are correct? Let me know what is the right answer and I'll give you 1 minute. What is the right answer? 30 seconds to go. Very dead easy, sir. Option B. Okay. And you know what happens when you say it is dead easy? Okay. The correct answer is D. None of these statements are correct. But now listen to me carefully. The purpose of asking this question is to make you aware of the law so that tomorrow you won't make a mistake. We can stop the poll now. And let me explain this question. For example, there is Section 8, Clause 1 of the Representation of the People Act. If a legislator is convicted under this section, and this section deals with terrorism, unlawful activities, if you are convicted under this section, and even if a fine is imposed, you are disqualified. You are disqualified, and then for 6 years you cannot contest election. I'll repeat. if a legislator is convicted under Section 8, Clause 1 of the Representation of the People Act, even if a fine is imposed, you are disqualified. And for 6 years, you cannot contest the election. If a fine is not imposed, but a sentence is imposed, which can be 5 years, 10 years, 15 years, for those 15 years, you cannot contest election. And once you are released, for the next 6 years also, you cannot contest election. Most dangerous section, Section 8, Clause 1 of the Representation of the People Act. Now there is Section 8, Clause 2 of the Representation of the People Act. Why I'm asking this question is because often students are confused. Because you read a lot of newspapers and newspapers say, because Rahul Gandhi was convicted and he was sentenced to 2 years in jail, that is why he was disqualified. And now for 6 years, he cannot contest election. That is correct, but that's not the true law. That's not the entire law. If you are convicted under Section 8, Clause 2 of the Representation of the People Act, which deals with hoarding, which deals with profiteering, which deals with offences under the Dowry Prohibition Act. If you are convicted under these offences and you are sentenced to 6 months in jail, you are disqualified. If you are sentenced to 6 months or more in jail, you are disqualified. Until the time you are in jail, you cannot contest election. And once you are released, for the next 6 years also, you cannot contest election. That is Section 8, Clause 2 of the Representation of the People Act. Then there is Section 8, Clause 3. And what does this Section 8, Clause 3 say? Those offences which are not mentioned under Section 8, Clause 1, those offences which are not mentioned under Section 8, Clause 2, other than them, any other offence if you have committed, you will be disqualified only if you have been sentenced to 2 or more years in jail. One such thing is defamation. So if you have been convicted for defamation and the punishment is given 2 years or more, then you will be disqualified for those 2 years, and once you are released for another 6 years, you cannot contest election. This is Section 8, Clause 1, 8, Clause 2, 8, Clause 3. So this statement is incorrect. Why? Because it says if a legislator is convicted under Section 8, Clause 1, but only a fine is imposed, then the legislator is not disqualified. You are disqualified, even if a fine is imposed. This statement is incorrect because it says if you are convicted under Section 8, Clause 2 of the Representation of the People Act and you are sentenced to 2 years in jail or more, only then you are disqualified. No. Even if you are sentenced to 6 months or more in jail, you are disqualified. Then if you are convicted under Section 8, Clause 3, which means those offences which are not mentioned under Section 1 or Section 2, you will be disqualified only if you are sentenced to 2 or more years in jail. If you are sentenced to 6 months in jail, 1 year in jail, you will not be disqualified. Clear? But if a government employee who has been dismissed from the service because of corruption, because of disloyalty, you are disqualified from contesting election, not for 6 years, but 5 years. Sir, will UPSC really ask these questions? This is a difficult statement, just replacing 6 with 5 or 5 with 6. This is to ensure that tomorrow you will not make a mistake. Maybe the statement may not be asked, but you have to be absolutely sure, because normally 6 years disqualification is for everybody. But for a government servant who is dismissed from the service, from that date when the dismissal order came, for the next 5 years, you cannot contest elections. Clear? So that is why none of these statements are correct. D is the right answer. Okay? Very good. Let's look at question number 3. The whip issued under the 10th schedule of the Constitution is binding in case of Rajya Sabha elections. According to the election conduct rules in Rajya Sabha elections, in case of equality of votes, the returning officer has the authority to decide between those candidates by a lot and proceed as if the candidate on whom the lot falls had received an additional vote. Which of these statements are correct? Let me know what is the right answer. Let's start the poll. That's what I was telling you, that now the questions would be easy. Okay. D is the right answer. How? 52nd Constitutional Amendment Act 1985, which added 10th schedule to the Constitution, which deals with anti-defection law. What are the provisions of anti-defection law? I know you know it, but briefly let me summarize. If you are a member of a house belonging to a political party, now the house can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, but if you are a member of a legislature and you belong to a political party, if you voluntarily resign from that party, you are disqualified. Clear? But after your disqualification, if you want to further contest the election, you can do that. That means you are not disqualified forever. You are not disqualified for 6 years. You are disqualified from that house. If you want, you can contest the election again. Clear? But Constitution says if you have voluntarily resigned, that does not mean that I as a legislator will have to formally submit my resignation letter to my party, and that would be viewed that I have voluntarily resigned from my party. If I am member of the parliament belonging to Congress, for example, I have not resigned from Congress, but I am doing something called anti-party activities. I am attending the rally of Mr. Modi. I am participating in the meetings of the BJP. I am not attending the meetings of the Congress. It may be construed that I have voluntarily resigned from my party. Even then, I can be disqualified. That's provision number 1. Provision number 2 is if I violate the whip issued by the political party. Now, whip is of 3 kinds. 1-line whip, 2-line whip, 3-line whip. If you have violated 1-line whip, 2-line whip, you will not be disqualified. If you have violated 3-line whip, the sanction behind this 3-line whip is coercive, which means if you will not follow this whip, you will be disqualified. And what do we mean by following this whip? If the party says vote in favor of confidence motion, if you are not voting in favor, you are voting against, disqualified. If you are abstaining from voting, the party clearly tells you that you should vote in favor. If you are abstaining, which means you have violated the whip, you are disqualified. Recently, a member to Rajya Sabha was nominated by the President, Ms. Sudha Murthy. A nominated member also becomes important in the news. This nominated member can join a political party after the nomination, but within 6 months. If she joins a political party 6 months after her nomination, she will be disqualified under anti-defection law. Similarly, I am an independent member of the parliament. For example, the member of the Lok Sabha from the Mandya constituency, who was elected independently without getting any ticket from any political party. If she would have joined a political party, she would have been disqualified. That means an independent member also cannot join a political party. That is why now she has decided to openly support the BJP. Because if she would have joined the BJP while she was the member of the Lok Sabha, she would have been disqualified. But this whip, it is not binding in case of Rajya Sabha elections. Now, why this whip is not binding in case of Rajya Sabha elections? Because we say this whip is binding in case of legislative procedures. For example, on money bill, vote of thanks on President's address, no confidence motion, electing or voting to elect an MP of Rajya Sabha, that's not part of the legislative procedure. When it is not part of the legislative procedure, that is why we say this whip is not binding in case of Rajya Sabha elections. But now you would say, sir, what happened in Himachal Pradesh? There were 6 Congress MLAs who did not vote for their candidate in the Rajya Sabha elections in Himachal Pradesh, but then they were disqualified. Were they disqualified for voting against their party candidate in the Rajya Sabha election, which means the whip is binding in case of Rajya Sabha election? No. What they were disqualified for was that they did not vote in the budget. They were asked, a whip was issued for a legislative procedure that you have to vote in favor of the money bill. You have to vote in favor of the budget. Since they did not, which means they violated the whip, and that is why they were disqualified. They were not disqualified for not voting for their party candidate in the Himachal Pradesh elections, in the Rajya Sabha elections from Himachal Pradesh. So long story short, the whip issued under the 10th schedule of the Constitution is binding in case of Rajya Sabha election. This is incorrect. And further statement can be, why this whip is not binding? Because election to Rajya Sabha carried out by the members of the Legislative Assembly, that is not the legislative procedure. That is outside of the legislative procedure. Clear? That's number one. Number two, now this is a strange rule. Rule 75 clause 4 of the election conduct rules of Election Commission of India. Normally what happens? If there is a tie, for example, same Himachal Pradesh, one member was to be elected to the Rajya Sabha. One candidate of the BJP, one candidate of the Congress. Congress candidate Mr. Singhvi, Abhishek Manu Singhvi. BJP candidate Mr. Mahajan. Both received 34 votes. Now in this case, what will I do? I'm the returning officer. I will have a box, drop two names in this box, mix it, then pick out a name. And whichever name appears, that person is the loser for Rajya Sabha elections, according to Rule 75 Clause 4 of the Election Conduct Rules. That means I take out a chit, whichever name appears, that person is the loser. So the name of Abhishek Manu Singhvi appeared, which means he is the loser, Mr. Mahajan is the winner. But in Lok Sabha election, it is reverse. If you and me are contesting elections, you got 34 votes, I got 34 votes, returning officer will drop our names in a box, mix it, take out a name. Whichever name appears, that person is the winner. So for Lok Sabha election, if the name comes out, that person is the winner. In the Rajya Sabha elections, if the name comes out, that person is the loser. The other person is the winner. According to election conduct rules in the Rajya Sabha elections, in case of equality of votes, the returning officer has the authority to decide between these candidates by a lot and proceed as if the candidate on whom the lot falls had received an additional vote. No. Incorrect. Both these statements are incorrect. D is the right answer. Clear? Any questions as of now? Yes, no, maybe? Okay. Candidate getting elected unopposed. This is an election season. So the entire election chapter, all rules, all laws, you should revise thoroughly because these elections come every 5 years. And this is where traditionally we have seen UPSC is asking a lot of questions on elections. When presidential election took place, the question on the president was asked. The question on presidential election was asked. So thoroughly revise this election chapter. Very important. Also the judiciary, because judiciary nowadays is often in the news. Candidate getting elected unopposed. We saw that in Surat. We saw it in Indore as well. Now what is this process? You have to file your nomination papers. Now, after filing your nomination papers, there is a time for you to withdraw your nomination papers as well. And once that time is over, then the nomination papers will be scrutinized by the returning officer. And after that, your name will be mentioned on the electronic voting machine, and then the elections, the voting will take place. Under Representation of the People Act, if I am a candidate, I have to contest election. I have the authority, or I have the power, or I have the freedom to submit 4 sets of nomination papers. Just in case if one is rejected, the other is accepted. That is rejected, the other is accepted. That is rejected, the 4th one is accepted. in case of Surat, the Congress candidate, he had filed 3 sets of nomination papers. Now, what is so important here? If you are from a recognized political party, a recognized national political party or a state political party, while you are filing your nomination papers, you need the name of one proposer as well. What is the concept of proposer? What is the qualification in order to contest Lok Sabha elections? I should be the citizen of India. I must have completed 25 years of age. I should be the registered voter in any parliamentary constituency of this country. Is that clear? Now, what if I am the registered voter in Delhi? Can I contest Lok Sabha elections from Surat? Yes, because I am eligible. I am the registered voter in any parliamentary constituency of this country. But if I am contesting from Surat, I need the voter of the Surat to propose my name. And a recognized political party needs one proposer. If it's a registered political party, then you need 10 proposers. So this Congress candidate, he submitted 3 sets of nomination papers, which means for every nomination paper, one proposer. For 3 nomination papers, 3 proposers. One proposer was his business friend, business partner. The other proposer was his nephew. The other proposer was his brother-in-law. When he submitted his nomination papers, the BJP candidate objected, saying this nomination paper is forged. Because these proposers, they have not given the proposal to propose his name. And then they also gave the affidavit before the returning officer saying we have not proposed his name. So the nephew is against this candidate, the business partner is against this candidate, the brother-in-law is against this candidate as well. Normally what returning officer should do, he should ask that candidate, come here and explain yourself. This candidate was absconding. Political parties previously said he has been kidnapped, but he was absconding on his own. Now in this case, what will happen? His nomination papers were rejected. There were 8 other independent candidates who were in the fray. They also withdrew their nomination papers, which means now who is the only candidate left? The candidate proposed by the BJP, and he got elected unopposed. That is the condition here. Now listen to me carefully. Condition number 1 is, how do you get elected unopposed? Condition number 2. What if we have an election, but there is no candidate filing the nomination papers? What if in Surat, we have no candidate who wants to contest election? In this case, what will happen to the election? Will election be conducted or not? There is no candidate. In this case, Election Commission will ask the people to file nomination papers again. Another notice will be given. Now please come and file your nomination papers. Now you might think, sir, what if in this case also nobody is coming forward to contest election? In this case, what will happen? The law is silent. It only talks about if at the first instance there is nobody who is willing to contest elections, then you reissue the notice again. At that time, there will be somebody who is contesting the election. If not, the law is silent. It does not talk about a third permutation and combination. So in this case, what will happen? Maybe I will go to that constituency, file my nomination papers and get elected unopposed because there is no one else who is there to contest the election. That's scenario number 2. Scenario number 3. What if there is an election boycott? Election boycott in the sense, what if there are 10 candidates contesting the election, but voters are not coming to the polling station to exercise their right to vote? In this case, what will happen? Will election take place? Who is the winner? This is where we come across this concept called equality of votes. Here, all those candidates who have received equality of votes, what will the returning officer do? Through a draw of lot, pick one name, that person is the winner if it's Lok Sabha election. Now we are 10 candidates contesting the election, but there is no voter who is exercising right to vote. There is no vote. It means all 10 of us, we are at the same level, equality of votes. We all are at 0. What the returning officer will do? He will drop our names in the box, mix it, randomly pick one chit, and whichever name appears, that's the winner. So that happens in case where there is a election boycott. Clear? Very good. Another concept recently, independent candidates. In one constituency in Tamil Nadu, Mr. OPS, O. Paneerselvam, who was previously the Chief Minister of Tamil Nadu, later on was expelled from his political party AIADMK, now is contesting election as an independent candidate backed by the BJP. But in his constituency, there are 5 other OPS. So these independent candidates, what they do, normally other political parties, they will look around and see who are these people with the same name as OPS so that we can confuse the voters. Because on the electronic voting machine, you have the name of the candidate. And when people will come out and vote, they will be confused. Who is the real OPS? Please stand up so that we can vote for you. Why this concept becomes important? Because the Law Commission of India, in its 255th report, Law Commission had recommended that independent candidates should be barred from contesting elections so that we can only have candidates from the recognized political parties and registered political parties contesting election. Because these independent candidates, these are dummy candidates, these are non-serious candidates, and these are meant to confuse the voters. That is why in Mathura, where Hema Malini was contesting last time, there were many Hema Malinis who were also contesting. Clear? What may also be asked is this. Look at the data. You don't have to remember year by year how many independents contested, how many independents won, but look at this chart. Consistently, we have seen this number is increasing. And what is this number? Percentage of independent candidates who forfeit their election deposit. I want to contest Lok Sabha elections. I have to also give security deposit. Let's say 25,000 rupees. If I'm from a reserved category, I have to give 12,500 as the security deposit. Once the election is over, if I get 1/6 of the valid votes, I will get this security deposit back. But if I will poll less than 1/6 of the valid votes, I will forfeit my election deposit. What you need to understand, number one, Law Commission of India recommended in its 255th report that independent candidates should be barred from contesting elections because these are dummy candidates set up by political parties to confuse the voters. These are non-serious candidates. Statement number 2, consistently since 1951, the percentage of those independent candidates who forfeit their deposit is continuously rising and it has crossed 99% as well. But consistently also what we have seen, that the number of people who have been contesting elections as an independent, there was a massive jump in 1996. After that, this number is stabilizing. Clear? Vice President is part of the Parliament but not a member of Rajya Sabha. Vice President is not a part of the Parliament. Parliament consists of, under Article 79, President, Rajya Sabha and Lok Sabha. Vice President is not part of the Parliament. In case of state elections, local body elections also, you draw a lot, whichever name appears, that person is the winner. Who is an independent candidate? Fayaz, you want to contest election? You approach the BJP, give me the ticket, they did not give it. You approach the Congress, they did not give you the ticket. Now you decide to contest independent elections on your own without the ticket by any political party. You are an independent candidate. Okay. Done. Question number 4. Or this concept, one more concept, refusal to vote. This is where the Hindu newspaper and other newspapers are wrong, and that is where we have to clarify. What is this refusal to vote? There used to be something called Rule 49 capital O of Election Conduct Rules. What does this rule say? I am a registered voter. My name is there on the voter list. Today is the date of polling. I approached the polling booth. I gave my identity card, and now they are satisfied that it is me who is the registered voter in this constituency. Please come and cast your vote, register your vote. But inside something happened. Maybe the presiding officer misbehaved with me, or maybe something happened. I am now refusing to vote. What I will do, I will tell the presiding officer that I don't want to vote. He will give me a form. I have to do my signature or give my thumb impression on that form, and what the presiding officer will say, this person has refused to vote. Clear? That is what we call refusal to vote, which is a different option than nota. Nota says you are not happy with any of the candidates set up by the political parties. None of the above. I'm not in favor of A, B, C, D. I don't want to vote in favor of anybody. That is why I'm pressing the nota button. But what if I'm against the very concept of elections? I had this option called refusal to vote under Rule 49 capital O of the Election Conduct Rules. But the year was 2013. Supreme Court said this rule is unconstitutional. Why? Because when I tell the presiding officer that I don't want to vote, and he gives me a form which I have to sign or give my thumb impression, and he will drop it in a parcel which says refusal to vote, which means this person has refused to vote, which means my secrecy is violated. One of the important characteristics of any voting system is that secrecy should be maintained at all costs. And since this Rule 49 capital O violated the secrecy, that is why it was declared unconstitutional by the Supreme Court. It was in the same judgment in 2013 that Supreme Court directed the Election Commission of India that you should give nota option to the voters. In the same judgment, this Rule 49 capital O was declared unconstitutional. So recently an article was published in the Hindu newspaper saying there is less awareness about this Rule 49 capital O. But you should be aware that this is not Rule 49O, this was Rule 49O, which was declared unconstitutional by the court. Clear? Done. Question number 4. Which of the following statements is or are correct regarding Article 142 of the Constitution? The order by the Supreme Court under Article 142 must be consistent with the fundamental rights guaranteed by the Constitution. Only the Supreme Court has the power to invoke this article. Easy question. Let me know what is the right answer. Election conduct rules were created by the Election Commission in 1971. What if 300 MPs are independent? Will there be any government then? Yes, these 300 MPs, they will come together and form the government. Which of the following statements are correct? C. Both these statements are correct. Under Article 142 of the Constitution, the Supreme Court has the power to issue any order so as to give complete justice. Clear? But in order to give complete justice, it is still bound by fundamental rights. It cannot violate fundamental rights. Your order has to be inconsistent with fundamental rights. And at the same time, only the Supreme Court has the power to invoke Article 142. But this is related to a concept we discussed yesterday, Delhi Metro Rail Corporation versus the firm of Mr. Anil Ambani. In that case, Article 142 was invoked because there was a grave, according to the Supreme Court, grave miscarriage of justice. According to the Supreme Court. And this was invoked in case when the court was hearing something we discussed yesterday, curative petition. And let me tell you something important, which can be important, can be asked in the examination, so that you should be prepared. Normally, what if this question is asked? Curative petitions are normally settled in circulation and not in the open court. What is the difference between these two terms? In circulation, in open court. Have you heard of these terms? Yes, no, maybe, or the mind is blank. Normally, the curative petition, which I told you yesterday, it is given to 3 senior judges of the Supreme Court and those judges who gave the verdict. But they don't come together to hear this matter. The case file is given to them in their chambers, they look at it and then they decide. Normally, curative petition is settled in circulation when the case papers are circulated to these judges. Rarely does it happen that the court hears this matter in an open court, where all the judges or all those judges who are hearing this matter, they come together and hear the party. It was rare for the Supreme Court in this Delhi Metro Rail Corporation to hear this curative petition in an open court and then at the same time invoke Article 142 so as to give complete justice. Because the arbiter had given an award in favor of Anil Ambani's company. Then the Delhi High Court had given the award in favor of Delhi Metro Rail Corporation. But Supreme Court overturned the Delhi High Court order. Even the review petition was in favor of Anil Ambani's company. But then the Supreme Court said there was no reason for Supreme Court to overturn the Delhi High Court judgment because that judgment was sound. That judgment was right. And we are trying to rectify the grave miscarriage of justice and we invoke Article 142 and now this Delhi Metro Rail Corporation need not pay 8,000 crores to Anil Ambani's company. Clear? Very good. Let's look at question number 5. Which of the following statements regarding the National Capital Civil Services Authority is or are incorrect? The authority makes recommendation to the Lieutenant Governor of NCT of Delhi regarding transfers, postings of officials and disciplinary matters. Number 2, it consists of the Chief Minister, Chief Secretary of Delhi and the Principal Home Secretary of Delhi. What's the right answer? Sir, what if all the votes are nota? That hasn't happened. The correct answer is D. None of these statements are incorrect because both these statements are correct. This is related to the tussle between the elected government in Delhi and the central government. And it dates back to when Aam Aadmi Party came to power in 2013 and then in 2015. Then there was a judgment by the court in Delhi saying, Chief Minister, the advice of the Chief Minister on the Lieutenant Governor is not binding because the real power is with the Lieutenant Governor. Then a landmark judgment was given in August 2018 by a 5-judge bench of the Supreme Court saying, no, the real power is with the Chief Minister. Any advice which is given by Chief Minister to the Lieutenant Governor is binding on the Lieutenant Governor. Why? Because we are a parliamentary democracy, and parliamentary democracy is part of the basic structure of the Constitution. But then we thought that this controversy is settled, but then the controversy was on services. Because you would know that in the distribution of powers, there are 3 items in the state list which are still with the center, which are still with the parliament when it comes to Delhi. Because the Delhi government or the Delhi Legislative Assembly cannot make a law on land, law and order, and police. But now the question before the court was, what about other areas? How can we appoint officers to those areas? We understand that when it comes to land, law and order and police, we have no jurisdiction. We are the Delhi government. But what about other areas? Then there was this tussle, and the Supreme Court said, no, even the services, they come under the Chief Minister and Council of Ministers, Delhi government. To overturn that judgment, the Parliament enacted a law, and through this law, what it created a National Capital Civil Services Authority, saying now it is this authority which will advise the Lieutenant Governor regarding appointment of secretaries. Clear? Disciplinary action if it is to be taken against these officers. And at the same time, this authority will consist of Mr. Kejriwal, the Chief Minister, the Chief Secretary of Delhi, who is appointed by the centre, Principal Home Secretary of Delhi. And now the quorum would be 2. Quorum means if there are 3 members of this committee, how many members should be present to take a decision? And the quorum for that is 2. Mr. Kejriwal is in jail, so the Delhi Chief Secretary and the Principal Home Secretary of Delhi will recommend to the Lieutenant Governor, appoint this person, remove that person, take action against this official, and the quorum is satisfied. This is the controversy. So you may be asked about National Capital Civil Services Authority. Can Supreme Court declare winner in parliamentary election like what it did in case of Chandigarh mayor election? Supreme Court can do anything under Article 142 of the Constitution. If you would have heard about the statement given by D. Lolme regarding British Parliament, because British Parliament is sovereign. Indian Parliament is not sovereign because there is a limitation on Indian Parliament. Indian Parliament cannot enact a law which violates basic structure of the Constitution. So there is a limitation on Indian Parliament. It's not sovereign. But British Parliament, there is no limitation. And that is why D. Lolme says British Parliament can do anything except convert a man into a woman and a woman into a man. We can say that in India regarding the Supreme Court. And I can go a step further and say Indian Supreme Court under Article 142 can do anything, even convert a man into a woman or a woman into a man. That's the power available with the Supreme Court under Article 142. Sir, while Supreme Court has asked the government to consider repolling in the constituencies where Nota has the majority of votes, no, the Supreme Court has not considered this. Supreme Court has not directed the government because Supreme Court cannot direct the government on this matter. If at all Supreme Court had to direct somebody, it is the Election Commission of India. Because the power of organizing elections is not with the government, it's with the Election Commission of India. Couple of years ago, there was a petition in the court saying if Nota gets the maximum number of votes, then in that case, the election should be conducted again. Voting should be conducted again. Supreme Court rejected this, saying election is a costly affair and we can't afford it in a country such as India. That is why even if Nota gets the maximum number of votes, who gets the second highest number of votes, that person is your representative, that person has won the election. Clear? But now, a week ago, the Supreme Court has issued a notice to Election Commission of India on the same matter. What if Nota gets the maximum number of votes? What should be the logical recourse in that case? And we'll have to wait and watch what court will have to say on this matter. Question number 6. Which of the following statements regarding the Places of Worship Special Provisions Act 1991 is or are correct? It prohibits conversion of any place of worship. It provides for the maintenance of the religious character of a place of worship as it existed on the 15th of August 1947. It prohibits ascertaining the religious character of a place of worship. Which of the above statements are correct? A, B, C, D. What's the right answer? Are independent candidates allowed to have star campaigners? No. Only the registered political parties and recognized political parties. What's the right answer? The law was passed in 1991. And this law, what it does, it prohibits conversion of any place of worship. And it also provides for the maintenance of the religious character of any place of worship as it existed on the 15th of August 1947. What does that mean? If on 15th of August 1957, there was a mosque, it cannot be converted into a temple later. It prohibits the conversion of any place of worship. It also provides for the maintenance of that place of worship. Same character. Same character. For example, this was a mosque belonging to one sect called Shias. It cannot be converted later on into a mosque for Sunnis. So it's not that you want to convert it from one religious place to another religious place. Even if this religious place belongs to one sect of that religion, it has to remain the place of worship for that sect only. It cannot be converted again. But now, at that time, we also saw that area which was known as Babri Ram Janmabhoomi at Ayodhya. This was kept out of the purview of the Places of Worship Act. And if you violate this act, there is 6 months imprisonment and fine as well. But then we also saw last year and this year also issues related to Gyan Vyapi Mosque in Varanasi, Shahi Eidgah in Mathura, and then the petitions were filed and the videography was also allowed. Archaeological survey was also conducted. When the matter went to the court, Supreme Court, Chief Justice Chandrachud said, what this 1991 law does, it prohibits conversion of a place of worship. It provides for the maintenance of the character of that place of worship. But what it does not bar, what it does not prohibit, we want to ascertain what is the character of that place of worship. So we can ascertain, we can find out what was the character of this place of worship on 15th of August 1947. That's why we can have archaeological survey. So this act does not prohibit ascertaining the religious character of a place of worship. So the question is asking which of the above statements are correct. B, 2 statements are correct. Because it prohibits conversion of any place of worship. It provides for the maintenance of the religious character of a place of worship as it existed on the 15th of August 1947. Clear? So somebody, Gauri, is asking for question number 5. Which of these statements is or are, that's why I mentioned here incorrect, because here the question was asking for incorrect. So both these statements are, which of these statements are incorrect? None of these statements are incorrect because both the statements are correct. Okay. Question number 7. Which of the following statements is or are correct? Both the Speaker of the Lok Sabha and the Chairperson of the Rajya Sabha has the power to suspend their respective members of the Parliament even without the approval of the Houses. If a member of the Parliament is suspended for the remainder of the session, then the suspension gets revoked only after the session is prorogued. In case of gross disorder, the presiding officer can suspend a member for 5 consecutive sessions. Which of the above statements is or are correct? Let me know what is the right answer. Thirty seconds to go. And sometimes apply logic as well, or common sense as well. A, one only is the right answer. Now, which is that statement which is correct? What we saw recently, 146 members, both in Lok Sabha as well as Rajya Sabha, were suspended. So suspension of the members of the Parliament becomes an important topic. And please understand, suspension is different from disqualification. If I am a member of the Parliament, I can be disqualified. On what grounds? If there is a change in the nature of my citizenship, if I have been declared mentally unsound, if I have been adjudged insolvent, bankrupt, if I am holding an office of profit, I can be disqualified if I have been convicted under Section 8, Clause 1, 2, 3 of the Representation of the People Act. I can be disqualified under the provisions of the 10th Schedule of the Constitution, which is anti-defection law. So disqualification is separate. We are talking about another concept then. You can also be expelled. For example, Mahua Moitra, she was expelled from the Parliament. That means she lost her membership of the Lok Sabha. She was expelled. And we have discussed her case yesterday. Today we are talking about suspension. What do we mean by suspension? And please understand, for Lok Sabha, it's slightly different as compared to Rajya Sabha. How is it different? The power to suspend an MP is with the Speaker, the presiding officer of the Lok Sabha. It is with the chairperson, the presiding officer of the Rajya Sabha. Clear? But who are and how are these people suspended? For example, I am somebody in Lok Sabha or Rajya Sabha. I am creating a ruckus, pandemonium in the house. What the presiding officer will say, you please leave. You are suspended for the day. The marshals will come, take me out, and for that particular day, I cannot come back to the parliament. This is the power with the presiding officer, both in Lok Sabha as well as Rajya Sabha. So in Lok Sabha as well as Rajya Sabha, the presiding officer, they will have the power to suspend that person for the remaining part of that day. Clear? In case of Lok Sabha, then something else happens. And that is something that we call automatic suspension. What is that automatic suspension? If I am the member of the Lok Sabha, but I am grossly, my behavior is disorderly. I'm coming to the well of the house. I'm raising slogans. I'm carrying placards. What the speaker will do? Speaker will name me. The speaker says, don't do this, don't come to the well of the house, don't raise slogans, otherwise I will name you. Don't do this, otherwise I will name you. And the moment speaker names this person, that is automatic suspension. You're automatically suspended. And maximum you can be suspended is for the remainder of the session. So if you're doing this in the budget session, for the entire budget session, you can be suspended. Or you can be suspended for the day. Or you can be suspended for 5 consecutive sittings, 5 consecutive days. Or the maximum suspension can be for the remainder of the session. This automatic suspension is not there in Rajya Sabha. It is there in Lok Sabha. That too by the speaker. But listen to me carefully. When speaker and the Rajya Sabha chairperson suspends a member of the parliament, you need the approval of the parliament as well. So if the chairman of the Rajya Sabha suspends me, he can't suspend me on his own. He has to take the approval of the Rajya Sabha. Similarly, Speaker of the Lok Sabha, if you have to suspend me, you can suspend me, but you need the approval of the House. So without the approval of the House, you cannot suspend me, whether you are the Speaker of the Lok Sabha or the chairperson of the Rajya Sabha. But the Speaker of the Lok Sabha has the power of automatic suspension. When you are coming to the well of the House, when you are raising slogans and placards, and when the Speaker is naming you, then that is automatic suspension. So that is what we say. Both the Speaker and Lok Sabha of the Lok Sabha and chairperson of Rajya Sabha has the power to suspend their respective members of the parliament even without the approval of the House. This is incorrect. Why? Because you have to seek the approval of the House. But Speaker can suspend you on his own without the approval of the House if you have come to the well of the House, if you are raising slogans, holding placards, and if I am naming you. If a member of the parliament is suspended for the remainder of the session, then the suspension gets revoked only after the session is prorogued. If the session is adjourned, does adjournment terminate the session of the parliament? No. If the House is adjourned sine die, does it terminate the session of the parliament? It does not. The session of the parliament ends only when it is prorogued by the president. That is why, unless and until the session is prorogued, you will continue to remain suspended, because you have been suspended for the remainder of the session, because that is the maximum suspension period. Clear? In case of gross disorder, the presiding officer can suspend a member. So if a member of the parliament is suspended for remainder of the session, then suspension gets revoked only after the session is prorogued. This is correct. In case of gross disorder, the presiding officer can suspend a member for 5 consecutive sessions. Not sessions, sittings. So this is incorrect. So only one statement is correct, which is statement number 2. Chairman can also name, but then you need the approval of the Rajya Sabha to suspend that person. What is the difference between adjournment and prorogation? Adjournment and prorogation. The power to adjourn the House is with the presiding officer. The power to prorogue the session of the Parliament is with the President of India. What is adjournment? Adjournment is a brief interval in an ongoing session. For example, you are interrupting me right now. Sir, what is the difference between adjournment and prorogation? It's a brief interval. Otherwise, we had to discuss questions. Similarly, in Parliament, you are raising questions, you are raising hue and cry. I say, as the presiding officer, the House is adjourned. We will meet tomorrow, 10 o'clock in the morning. Session is still the same. Budget session or monsoon session or winter session. Session remains the same. But it's a brief interval. Or the House is adjourned for the day because we have done a lot of work today. We'll meet tomorrow. That is brief interval in an ongoing session. Session remains the same. That's adjournment. That's the power with the presiding officer. Or, for example, there is ruckus in the Parliament. Please don't do this. Please don't lift chairs at each other, throw chairs at each other, microphone at each other. Please don't do this. There has to be discipline, decorum in the House. Since right now we can't have the business because there is pandemonium in the House, there is ruckus in the House, indiscipline in the House, I'll say the House is adjourned. We will meet 2 o'clock in the afternoon. It's a brief interval in an ongoing session. But prorogation is the session is terminated. Who has the power to summon Parliament? President. Who has the power to terminate the session of the Parliament? President. On the advice of the government. That's the difference between the two. Dissolution is when Lok Sabha is dissolved, which is when the 5-year term is over, or at any point in time the Prime Minister can advise the President that please dissolve the Lok Sabha. Vice President is appointed by President, but after elections for Vice President? Vice President, my dear, is elected by the Electoral College, consisting of members of both houses of the Parliament. Vice President is not elected by the President. Okay, question number 8. Which of the following statements is or are correct? NGOs registered under FCRA Act are required to provide detailed information about movable and immovable assets created using foreign contributions. Contributions made by a non-resident Indian is treated as foreign contribution. Which of these statements are correct? Think. Hell of a life is getting all the questions wrong today. Which of the following statements is or are correct? Recent changes which have been made in the FCRA rules. NGOs registered under FCRA Act are required to provide detailed information about movable and immovable assets created using foreign contributions. This is correct. So as to ensure that funds are not misused by these NGOs. Contributions made by a non-resident Indian. But if you are making this contribution from your own account, or own savings account, it is not treated as a foreign contribution. No. So which of the above statements is or are correct? A, one only is the right answer. Okay. Now let me explain. Foreign Contribution Regulation Act, it was originally enacted in 1976. When the country was in the state of emergency, when Shrimati Gandhi was the Prime Minister. Then that law was repealed and this FCRA was enacted again in the year 2010. But significant amendments were made to Foreign Contribution Regulation Act in the year 2020. significant amendments were made. And what were these amendments? Listen to me carefully. Initially, foreign contribution, that means basically money from abroad. There were some individuals, some entities which were prohibited from receiving these foreign contributions, such as election candidates. They cannot receive foreign contributions. Judges, political parties, cartoonists, publishers of the newspapers, so on and so forth. In 2020, another item was added to this list, those who cannot receive foreign contribution, and that entity was public servant, somebody who is a government employee. Public servants also, they cannot receive foreign contribution. That's change number 1. Change number 2, you need an FCRA certificate or an FCRA license. For example, if I am a NGO or a body or an institution and I want to be eligible for getting or receiving this foreign contribution, I have to apply for FCRA license. Clear? Now assume A also has this license, B also has this license, but A received, let's say, 10 crore in foreign contribution. Before 2020, A could have transferred some amount of this foreign contribution to B as well, because you and me, we both are registered under FCRA, we both have FCRA license. Now I have received foreign contribution, but you have not, or you have received less. What I can do, I could have given a part of this foreign contribution to you. I could have transferred a part of this foreign contribution to you. What 2020 amendment does, it removes this possibility. If you have received foreign contribution, only you can utilize it. You cannot transfer it to any other entity who was, by the way, eligible for foreign contribution. That's change number 2. Change number 3, which has taken place, my NGO, we have received 100 crores as foreign contribution. I could have spent 50% on administrative expenses, salaries for my employees, travel, rent, so on and so forth. What 2020 does, it reduces this to 20%. Now this entity which has received foreign contribution, who is eligible for foreign contribution, you can spend only 20% of your contributions for administrative purposes, not 50%. Another change has taken place. And what is that another change? The change is, if you want to renew your registration, your FCRA registration is valid for 5 years. Now you have to renew it. You have to renew it within 6 months of the expiry of that registration. And when you are renewing it, you have to give Aadhaar details. Aadhaar details of whom? Office bearers, directors, key members. You have to give Aadhaar details. Another change. But massive change is FCRA bank account. What is this FCRA bank account? If I am an entity who is eligible for foreign contribution, I could have opened a bank account in any part of this country, and in that account I could have received this foreign contribution. But the change made in 2020 said, no, the government will specify In which scheduled branch or scheduled bank can you open this bank account and where? And the rules later on released by the government said you can open this bank account only in State Bank of India and branch will be the Parliament Street branch. That means previously the NGO or an institution which receives foreign contribution, it could have received this foreign contribution in any bank and branch of their choice. Now it is the choice of the government. Now State Bank of India, Parliament Street branch, this is where you can receive your foreign contribution. These were massive changes that were made in 2020, and recently also we have seen a lot of NGOs, in fact universities as well, where the FCRA license was cancelled. And the most high profile case was that of Centre for Policy and Research, whose FCRA license was initially suspended. So previously, before 2020, your FCRA license could have been suspended for 180 days. 2020 amendment said your FCRA license can be suspended for additional period of 180 days. So for Centre for Policy and Research, it was initially suspended and later on it was cancelled. Now they can't raise money through foreign contribution. Clear? Any questions as of now? So we are almost reaching 9 o'clock, but we will still discuss question number 9. Okay. The Lokpal and Lokayuktas Act of 2013 has been amended only once since its enactment. The Lokpal is vested with the power of search and seizure and power of attachment of assets. Attachment of assets we have seen in the news of PMLA, the ED does this. So can Lokpal also do this or not? This is where you will have to link. A complaint under the Lokpal Act must pertain to an offence under the Prevention of Corruption Act 1988 against a public servant. Which of the above statements is or are correct? It's an easy question. Let me know. Can President use pocket veto for a money bill? No. President can either give her assent or withhold her assent. She can publicly declare, I'm not going to sign this bill. NewsClick is a news website. Can a money bill of state legislature which is referred to President by governor of that state be returned by President for reconsideration? President can do anything with a bill which is reserved by the governor. Let me know what is the right answer. Does Vice Chairperson come under Parliament? You're talking about Vice Chairperson or the Deputy Chairperson of Rajya Sabha. He is a member of the Rajya Sabha. The Lokpal and Lokayuktas Act of 2013 has been amended only once since its enactment. Correct, it was amended in 2016. The Lokpal is vested with the power of search and seizure and power of attachment of assets. Correct. A complaint under the Lokpal Act must pertain to an offence under the Prevention of the Corruption Act against a public servant. This is also correct. So, 3 statements, all of the above is the right answer. India is a signatory to United Nations Convention Against Corruption. And in response to that, this law was passed. So this bill, one thing you should know, when this Lokpal was introduced, this bill was introduced under Article 253 of the Constitution. Because under Article 253, the Parliament has the power to give effect to any international agreement or a treaty that we have signed. Lokpal consists of chairperson and 8 members. Is that clear? 50% of these members should be judicial members. Who are these judicial members? Those who have been ex-judges of the Supreme Court or ex-Chief Justice of a High Court. In February 2024, we saw Mr. Khanvilkar, Justice Khanvilkar, who was the judge of the Supreme Court, was appointed as the Lokpal. And we also saw that Lokpal has now ordered CBI investigation into Mahua Moitra allegations. So Lokpal becomes an important topic. All these chairperson and members, they are appointed by President. But how are they appointed by the President? President appoints them on the basis of the recommendations of a committee. Who are the members of this committee? Prime Minister, Speaker of Lok Sabha, Leader of the opposition in Lok Sabha, or Leader of the single largest party in Lok Sabha, Chief Justice of India, and an eminent person. But how is this eminent person chosen? This eminent person is chosen by these members through unanimity, by unanimity, in a unanimous decision. And Mr. Mukul Rohatgi, who was the previously Attorney General for India, was appointed or nominated as the eminent person. Clear? Chairperson gets the salary of the Chief Justice of India, the same salary as the Chief Justice of India. And these 8 members, they get the salary of similar to the judges of the Supreme Court. What is the term? Both the chairperson and the members, they hold office till they attain 70 years of age or till they complete 5 years at Lokpal, whichever is earlier. Clear? And what does this Lokpal do? It investigates all those complaints which come under corruption or Prevention of Corruption Act 1988. So it can investigate or it can look into complaints even against Prime Minister, even against cabinet ministers, even against ex-prime ministers as well, even against public servants who are group A, B, C, D. Clear? And listen to me carefully. This Lokpal can also investigate against those bodies or organizations which are set up by the Act of the Parliament. So any body or a society which is established by the Act of the Parliament, Lokpal can investigate corruption there. Not just that, those bodies or trusts or societies which get funding by the government or major stakeholder, major shareholder is the government, even those organizations, societies can be investigated by Lokpal. And more importantly, since we were discussing Foreign Contribution Regulation Act, any body which receives foreign contribution of 10 lakhs or more in a financial year, such a body can also be investigated for corruption by Lokpal. And Lokpal can then direct CBI that you conduct this investigation. So CBI normally, there was one famous judgment of the court when UPA government was in power, where the Supreme Court referred to CBI as a caged parrot because you're parroting the words of the ruling government. So there is an allegation that CBI is under the grip of the government. Enforcement Directorate is under the control of the executive. But when a complaint is sent by Lokpal to CBI that, for example, you investigate allegations against Mahua Moitra, the superintendence of CBI will be under Lokpal. So while investigating that case, CBI will not come under the pressure of the government. It will be under the superintendent's control of the Lokpal. So these details are very important for you to understand and can be important for your prelims examination. Yes, any questions? Otherwise, we will wrap the session. Article 252 is, if two or more states request the Parliament to make a law on any item mentioned in the state list, Parliament becomes empowered to make a law on state list. Lokpal is working. Is it now mandatory for governor to state reasons why you are... Where is that question? Reasons why you withhold your assent? Not just that. What the Supreme Court said in Punjab case, because there were some bills which were withheld by Punjab governor, and same happened with Kerala as well, with Tamil Nadu as well, with Telangana as well. What Supreme Court did, Supreme Court basically merged two vetoes, absolute veto and suspensive veto. Normally what would happen? If a bill is passed by the state legislature, sent to the governor says, publicly declares, I am not going to sign this bill. That was the death of the bill is dead, it will never become a law. Then there was another power. The governor could have sent the bill back to the legislature for reconsideration. But once the same bill is passed again, the governor has no other option but to sign it. What the Supreme Court said if the governor is withholding her assent or his assent, publicly declaring that I'm not going to sign this bill, that does not mean this bill will be dead. It will never become a law. You have to then immediately send this bill back to the state legislature. And if the state legislature sends the same bill again, you have no other option but to sign it, because we are in a parliamentary democracy. Okay, then that is it for today. Thank you so much for staying with me. And once again, towards the end, do your bit of encouragement. Don't exit the session unless and until you like it. And drop in your comments once the session is over. Until then, have a great time. We'll meet tomorrow, 7:30 p.m. in the evening. Till then, goodbye. Good night.